Question is that the bill be now read a second time. Mr. Pritam Singh.
Sir, as the Select Committee report on deliberate online falsehoods observes, the phenomenon of fake news is nothing new. Since time immemorial, a battle for hearts and minds has taken place between people who host different views and seek to persuade others of their beliefs and causes. Between politicians at the hustings, between companies through elaborate public relations exercises and spin, and between countries, most vividly played out during the Cold War between the US and the former Soviet Union, each forwarding the superiority of the capitalist and communist systems respectively. What we refer to as fake news today, with misinformation and disinformation at its core, has been the domain of propaganda in the days before the internet. As framed by Claire Waddell in her submission to the Select Committee, at one end of the spectrum, misinformation has been a method of choice of individuals, politicians, companies and countries. Here, misleading content, false context, imposter content dominate. At the other end is aggressive disinformation with falsified or manipulated content which seek to deceive an audience or a reader. This is usually the domain of sophisticated state and well-endowed non-state actors. The advent of the internet and more recently social media, where communication has been democratized with both positive and negative repercussions, has brought the ease of propagating fake news center stage. The political economy of social media companies and their algorithms, which are skewed at extracting profits, in some cases regardless of the consequences, accentuate the problem. Bots and the existence of enterprises that charge for services to manipulate the public discourse, subvert democracy and elections, and weaponize information have become a feature of the online world, with many examples highlighted to the Select Committee. Over the last few years, Western powers have identified Russia's employment of hybrid warfare, combining both a hostile information campaign employing both misinformation and disinformation before and during the onset of hostilities as a norm for future conflicts. However, it would be a mistake to suggest only Russian involvement. The arc of history has proved that many countries, even those friendly to Singapore, are no less seasoned at subversion and subverting even democratic forces in other countries. And it would be naive to assume that the employment of misinformation and disinformation is not a permanent aspect of the world we live in today, much of which is lived online. Clearly there is a problem at hand. The question is, how should Singapore deal with the problem? The government has proposed the Protection Against Falsehoods Online and Manipulation Bill before the House today, what I will henceforth refer to as POFMA. After spending a long time deliberating the nature of the problem, including forming a Select Committee of Parliament, the government decided not to consult the public on how it preferred to tackle the problem. To this end, a lot of the public apprehension over the bill can be located in its choice of decision-making authority on matters concerning online falsehoods, the executive. The remedies available under the bill are virtually identical to those individuals and companies can rely on under the Protection from Harassment Act, or POHA. In deciding that the executive will determine what an actionable falsehood and what is not, there has been significant disquiet even amongst moderate and politically disengaged members of the public about the potentially wide remit of powers extended to ministers through this bill. So the public routinely get involved in political discussions, both online and offline, on the effectiveness or ineffectiveness of policies, the appropriateness of executive action, the lack of information on matters of public interest, such as the size of our reserves, amongst many others. By their very nature, such discussions are also limited and even exaggerated sometimes because of a lack of disclosure by the government, or the absence of any freedom of information regime to equalize the asymmetry of information between, I'll say that again, to equalize the asymmetry between the information and facts available to the executive as compared to the general public. Given our unique laws that govern how the press operates in Singapore, the infamously local phrase out of bound markers, and our unique political culture steeped in a history of hauling up members of the public and politicians who uttered defamatory statements to court to be slapped with punitive damages, there is a genuine sense amongst the public that this bill can be easily abused in the wrong hands. It does not help that the public do not appear to be clear on what can be said and what cannot be said. For example, how does a false statement of fact interplay with an opinion or comment? I believe the Minister also recognizes this point in comments to the Straits Times last Saturday about whether the bill could have the unintended effect of self-censorship. Minister said, and I quote, we need to educate the public that the bill applies only to people putting out falsehoods and that various ministries like the Education Ministry is working on public education in this area, unquote. Mr. Speaker, the Workers' Party opposes this bill. All the Workers' Party MPs will speak against it, and our objections center primarily around a fundamental matter. First, we do not agree that the executive should be the initial decision maker on matters surrounding false statements of fact. Secondly, we do not support the uncertainty over the circumstances under which the executive can move on matters that rest purely on a minister's subjective opinion that a false or misleading statement is nonetheless not in the public interest, for which a correction or takedown order, amongst other directions, are necessary. While the government must legitimately be able to apply to shut down malicious actors, a court order should legitimize this action that needs to be undertaken. In fact, the Select Committee report noted representatives raising the prospects of the executive itself spreading falsehoods. This should give all Singaporeans reason to pause and consider whether the bill that will be passed with the executive as the decision maker is truly in the best interest of Singapore. In fact, it is my case that POFMA can easily become a proverbial Damocles sword that would hang over members of the public who do not support the government's narrative or toe the government line. So it would be useful for the House to revisit Recommendation 12 of the Select Committee report and the analysis that precedes it. Here, the committee's report deliberated on which entity should become the decision maker in determining what is a falsehood. In fact, the Select Committee outlined three other alternatives. First was the courts. The second was the establishment of an independent body or ombudsman that would issue directions. And thirdly, the report considered the prospects of social media companies themselves acting upon notification of falsehoods by users with a recourse to the courts. At paragraph 364 of the Select Committee report, the committee acknowledged the views of some representatives, including those who were skeptical of the executive as the decision maker. Ironically, much of the concern that has been expressed in the public realm since the first reading of the bill was actually foreseen by the Select Committee report. At para 364b3, it read, and I quote, representatives raised concerns about whether executive action would be credible. There was concern that executive action could feed fears over the abuse of power. It was also pointed out that executive directions would not be able to deal with falsehoods spread by the executive. In contrast, the proposal to have the courts as the decision maker did not elicit any significant apprehensions. To reinforce this point, it is apparent that the bill gives remarkable leeway to the executive to define what a falsehood is, especially since the government has said that it will not act on all falsehoods. In fact, Clause 2.2 legislates that a statement can be deemed by the government to be false if it is misleading, whether wholly or in part, and whether on its own or in the context in which it appears. In the public understanding, this clause gives broad latitude to the executive to clamp down on what it deems to be even misleading statements, which may not be false per se. In fact, it is fathomable that some statements the executive may interpret as offending are likely to exist along the misinformation and disinformation spectrum eloquently laid out by Claire Wardle in her submission to the Select Committee. Some statements would exist in the middle of the spectrum where reasonable people would disagree about whether such an offending statement is indeed prima facie false or misleading and against the public interest. In addition to Clause 2, Clause 10 legislates that any minister can issue a whole range of directions if that minister is of the opinion that it would be in the public interest to issue it. Clause 4 lists 6 broad considerations of what would be in the public interest. Reference is also made to a diminution of public confidence in the government, a term I would argue can turn on how thin-skinned or thick-skinned the government of the day is, be it today or in the future. For example, some weeks ago, some critics of what many reasonable people would consider, correctly or incorrectly, to be a pro-government influencer, Nas Daily, were accused of seeking to undermine confidence in public institutions. These critics alleged double standards on the part of the executive in allowing the applicant, a foreigner, to mark his presence in Singapore because of a different interpretation of what the executive would deem to be a cause-based event. This led the Singapore Police Force to release a statement which framed the allegations of the critics as, I quote, a malicious attempt to undermine confidence in public institutions, unquote. So if this example, rooted in a different perspective of how the Public Order Act is applied, outlines the contours of what the threshold of undermining public confidence as defined in the bill is, then the irresistible conclusion must be that the public interest limit detailed in Clause 10 can potentially be very easily invoked by the executive. Such a conclusion would explain why even moderate Singaporeans have raised concerns about the prospect of POFMA having a chilling effect on the public discourse at the hands of a very easily triggered executive. Now, if an exceedingly low threshold to trigger Part 3 was not enough, the explanatory statement of the bill at page 69 clarifies that the 6 scenarios of what would qualify as the public interest are actually only the tip of the iceberg. I quote the explanatory statement. Clause 4 gives a non-exhaustive, and let me stress this again, a non-exhaustive definition of the expression in the public interest, which is part of the condition for making the various directions under this bill, unquote. So in fact, what this bill is really saying is that Clause 4 is merely a precursor to another potentially unknown list of definitions of what could be in the public interest. Mr. Speaker, we have had episodes in our history where decisions made by the executive, by the virtue of powers legally exercised, were questioned with skepticism by members of the public, including even members of the executive years after the event. Operation Spectrum, or the Marxist conspiracy of 1988, is a good example. It is public knowledge that a senior cabinet member left the cabinet after expressing doubts about the executive's exercise of powers under the Internal Security Act. Senior Minister Tharman Shanmugaratnam was also quoted by the media as being doubtful about whether the individuals arrested in 1988 were communists. These are not the opinions of lay members of the public who have access to all the relevant information and individuals involved to make a decision or clarify their understanding of events. It would appear that reasonable people, even within the executive, would opine very differently on some matters. But yet each minister can invoke powers under this bill, even if a fellow minister may not be in agreement. To avoid such inconsistency, wouldn't the courts represent a more neutral, transparent, accountable, and uncontroversial platform to rule on such matters? The government has argued that under the proposed bill, the courts are the final arbiter of truth and that an uncomplicated appeals process to the courts would address the concerns of aggrieved parties. Even so, sir, the judicial culture in Singapore is highly non-interventionist. The courts cannot overrule executive directions lawfully undertaken pursuant to legislative powers passed by this House. False statements, which can include misleading ones, nonetheless require the independence and neutrality of a reasonable man who, in this case, will not be a judge in the first instance, but a PAP minister. It is open to question whether a traditionally non-interventionist judiciary will challenge what the executive deems to be reasonable under the bill, particularly in the face of broad definitions like misleading statements and the public interest. Furthermore, an appeal to the High Court for a Part 3 direction under Clause 17 does not give leeway to the court to order what is just and equitable in the circumstances, powers which a genuinely neutral appellate authority must ordinarily host. Instead, POFMA limits the grounds for appeal to the courts to 3 circumstances as listed in Clause 17. While judicial review nonetheless applies, it is a high bar as judicial review does not cover the merits of the minister's decision but only its legality. More fundamentally, the executive will have to carefully assess and determine what constitutes a statement of fact, something which is not necessarily a straightforward exercise. What is not stated in unequivocal terms by the government is that the line between satire, opinion or comment and what the executive may deem to be a false or misleading statement of fact in the public interpretation can be highly subjective. This point was raised in the Court of Appeal judgment in Review Publishing versus Lee Hsien Loong, quoting Evans on defamation, albeit in the context of the defense of fair comment, where it was said, and I quote, "It will often be very difficult to decide whether a given statement expresses a comment or an opinion, or by contrast constitutes an allegation of fact. The same words published in one context may be statements of fact, yet in another may be comments. Therefore, whether this element of the defense is established as one of fact is dependent on the nature of the imputation conveyed and the context and circumstances in which it is published. The test in deciding whether the words are fact or comment is an objective one, namely whether an ordinary reasonable reader on reading the whole article would understand the words as comments or as statements of fact. However, in acknowledging that deciding between an opinion or comment and a fact can be a difficult exercise, to say nothing of misleading statements, it would follow that the application of a nonetheless objective test in some cases may likewise not be a straightforward exercise, especially in cases of misleading statements where politically charged decisions need to be made. Mr. Speaker, it would appear that a key factor in the government's selection of the executive as opposed to the courts as the decision maker on matters concerning falsehoods and manipulation turn on how quickly a false statement of fact can be corrected, removed, and generally dealt with speedily. If so, it would be important to put this factor into perspective and consider alternatives that seek to balance the urgency of moving against an online falsehood and having a decision maker that is more acceptable than an unchecked executive. Firstly, under civil law, quick remedies are available where service and the presence of a respondent in court can be dispensed with. And to this end, the ex parte process is not an unusual judicial remedy to deal with certain time-sensitive applications. But one need not reinvent the wheel here. The prospect of interim orders made in favor of the government in the face of a prima facie falsehood, just like how an individual or company would apply under POHA, can possibly also operate to deal with online falsehoods and manipulation quickly and effectively. To this end, Part 3 and 4 of the bill have close similarities with the remedies for online falsehoods this House passed earlier under Part 3 of POHA. The new Section 15 and 16 of POHA envisages identical remedies such as stop publication and correction orders that can be invoked by companies and individuals in Singapore, in addition to orders sought against tech companies upon application to the harassment courts. Mr. Speaker, if ordinary Singaporeans and corporates registered here are expected to apply to the courts to deal with online falsehoods and misleading statements made against them, it would be sensible for the executive to surrender itself to such a process as well, particularly since the meaning of a falsehood is identical under both POHA and the bill. The harassment courts dealing with all online falsehood applications from individuals and companies and the government would also result in a consistent application of the law in matters involving online falsehoods and misleading information, resulting in not only greater clarity for all parties, but would help in public education on permissible and impermissible forms of expression. In cases of sensitive matters involving national security, in-camera applications can be made by the executive to the harassment courts. To this end, I believe there is scope to introduce processes involving duty judges to deal with an urgent application from the government speedily or at very short notice. Likewise, there can be times where there is heightened risk of false or misleading postings online. This can happen during elections, for example. In such a scenario, urgent interim orders can be ordered by duty judges available at short notices to quickly deal with false content that threatens to subvert the election process. The difference in time taken between an executive direction and an expedited order through the judicial process in such cases may not be significant. Here, I think it's helpful for me to bring back the clarification from Senior Minister of State Edwin Tong that in the case of an online falsehood that threatens to go viral in 4 to 5 hours, if I heard SMS correctly, the answer was the courts can try to deal with that situation. Now that suggests that there is some room for the courts to deal with issues speedily. And on the other hand, an aggrieved party is also free to apply to the courts to challenge, vary, suspend or cancel a court's decision. In conclusion, Mr. Speaker, the Workers' Party is of the view that as a matter of principle, the courts should be the decision makers at the very first instance on matters that pertain to deliberate online falsehoods and manipulation. The fact that the bill would have to regulate what some reasonable people may well interpret as an expression of free speech under Article 14 of our Constitution must give us reason to pause and question whether the courts are better placed to exercise judgment on this point. The fake news domain is already a very controversial one. Some players are sophisticated, others will fake innocence when rightly called out. Some misleading statements will be completely political in nature, aimed at lowering the esteem and political prospect of election candidates, and there would be conceivably a whole litany of other scenarios and circumstances to consider. On its part, the executive will act in some cases of falsehoods, and in other cases it will not. In both scenarios, questions will be asked why the executive acted as such. Suspicions will be raised and perceptions could be formed. Politicization would be inevitable. But it is precisely because of these very reasons that the decision maker must be perceived to be free of conflict in deciding on matters concerning online falsehoods and manipulation as defined by the bill. Thank you.
Ms. Irene Quay. Senior Minister Edwin Tong.
Yes, Mr. Speaker. I have a clarification on Mr. Singh. He quoted me earlier in my speech in the Poha debate. Would Mr. Singh accept that while I said that the courts can try, I went on to say that it would be very difficult, and I went on to explain also that in the context of these kind of cases, it would be extremely difficult for a court to have a proper marshalling of the details and the facts and to decide on the case. I went on to explain all of that.
Mr. Speaker, I can confirm that there was an additional explanation to that initial comment that I beg your pardon, sorry?
In the terms that I have just set out.
Yes. The point I think that needs to be made here with regard to the use of the courts is that with an expedited procedure, which the Minister also confirmed under POHA, simple claims form, there is room, in my belief, that the courts can still represent decision-making authority which can act speedily.
The point that Mr. Singh is trying to put across is that the courts can do so in a matter of, and I think to say in your words, 5 to 6 hours. And I had explained earlier that whilst the courts can try, it will be very difficult to do so, especially having regard to the fact that they would have to assess the merits of the matter, and it's not possible to bring the case within that period of time.
Mr. Pritam Singh.
Mr. Speaker, I can accept the Minister's position on that, but philosophically I have a different view as to who the appropriate decision maker is, and it is my belief that we should try and see how the courts can deal with these falsehoods as quickly as possible.
That may be Mr. Singh's philosophical position, but he was trying to quote my speech to make that point, and I don't think that's accurate.
Okay, we note the positions taken.